Today, I want to give a quick overview of felony sentencing in California. So, if you're convicted of a felony, you will have a sentencing hearing where the judge will decide what sentence or what penalties to impose. And at a sentencing hearing, the judge really has two calls to make. First of all, whether to grant probation. Almost every crime allows the judge discretion to grant probation. And this is where the judge says basically, I'm going to go easy on you, I'm going to give you a chance, I'm going to put you on probation. Now, with probation, the judge can still sentence you to up to a year in county jail. But oftentimes when the judge grants probation, there's no jail time at all. The judge merely says, I'm going to have you on probation for 3 to 5 years, and if you do everything correctly, at the end we'll dismiss your case and expunge it. If you violate your probation, then we can send you to jail or prison for up to the maximum term. If the judge elects not to grant probation, then the judge has to decide, do I impose a low, middle, or high term? Now, almost every crime has a sentencing range of a low, middle, or high term. For example, grand theft has a low term of 16 months in custody, a middle term of 2 years in custody, and a high term of 3 years in custody. Generally, the middle term is presumed unless there are mitigating or aggravating circumstances. Now, mitigating circumstances are things in your case that would call for leniency. So, for example, if you have no prior record, if you played only a small role in the crime, if you took care to make sure that nobody got hurt, if your motive for committing the crime was to provide food for your children, all of these would be considered mitigating factors. Then there's aggravating factors. Aggravating factors are things that would call for a tougher sentence. So, for example, if you have an extensive record, if you were already on probation, if you used a weapon, if multiple people were injured, or there was a great loss of money to the victim. These would be considered aggravating circumstances. So basically, the judge weighs the mitigating and the aggravating circumstances. If the mitigating circumstances outweigh the aggravating circumstances, then the judge is supposed to impose the low term. On the other hand, in a more serious case where the aggravating circumstances outweigh the mitigating circumstances, the judge is supposed to impose the high term. This is where a good criminal defense attorney comes in. We can emphasize the mitigating factors and show why the aggravating factors should be discounted. At a sentencing hearing, a good defense attorney can go a long way towards convincing the judge to impose the low term or to grant probation and impose no jail time at all.